Good morning, Your Honor. My name is Gurinder Singh Gill, and I'm before you on the behalf of defendant Ms. April Morris to make an application for bail under Bails Act 1977, Victoria Section 8. Your Honor, may I proceed with my application? On Thursday at 10:30 p.m., Ms. April Morris was arrested and charged by police with 4 offenses. The offenses were under the Summary Act 1966, Section 32, Common Assault, Crimes Act 1958, Section 18, causing injury intentionally or recklessly, Summary Offence Act 1966, Section 13, persons found drunk, Summary Offence Act 1966, Section 9, willful destruction, damages of property. Your Honor, before proceeding, I would present some facts and background information about Ms. April Morris. Ms. April Morris is 27 years old, born and raised in Melbourne, and currently working full-time in marketing and earning $125,000 salary. She has significant savings of more than $50,000 in bank and have shares of approximate value $75,000. Moreover, she holds a commercial pilot license. In the past, she had an event where she got worried about her own security, and due to the fact so that in an event such a situation arise in the future, she decided to learn martial arts. As a result, she learned Zen Do Kai and practiced this style of martial arts for previous 4 years and has earned black belt. Currently, she is living in a same-sex relationship with her partner Paulina of 2 years. 5 years ago, she was caught driving while her driving license was suspended, and although there was no conviction recorded. Apart from this offense, she had a clean record. I understand the police are opposing the bail and highlighting the following facts. The scandal required medical attention, including 9 stitches to her forehead, bruises and abrasions, and quite traumatized by the event. Moreover, this incident led to a damage of more than $300,000, and the police is worried about Miss Morris' childhood friends who are associated with the local crime gang, and one of them is the president of the gang. Your Honor, in support of the bail application, I would like to present the following facts and hope you agree with the arguments. Summary Offence 1966, Section 13, person found drunk. Under Bails Act 1977, Section 17, police could grant bail for this offence with a security bond of $50, cash deposit as security for plenty. Crimes Act 1958, Section 18, causing injury intentionally or recklessly. Miss Morris was with her partner Pauline and had a few drinks that evening. Miss Kendall was also present at that venue and repeatedly taunted Miss Morris and her partner with insulting slurs as both were holding hands. Miss Morris verbally requested first and then warned her to stop verbal attack. Miss Kendall discarded all the warnings, and eventually the situation comes to a physical altercation between the parties. Miss Morris did suffer some bruises, and unfortunately Miss Kendall got hurt more. Miss Morris has never met Miss Kendall before, and her behavior that evening was very sober and gentle until this altercation. Footage from that evening is available to prove my point. So by no means it was pre-planned or premeditated. Since this incident, Miss Morris is very remorseful and stressed that she should have dealt with the situation differently and had made a bad choice which is out of her character. As the police stated, she regularly put content on social media and considered influential by her followers. This sort of behavior will have negative impact on her fan following. Prisons could be dangerous and unhealthy places, and the police and court cells often lack natural light and facilities. Miss Morris' allergy to penicillin and hay fever must be considered while making decision on her bail. Refusing her bail and putting her behind bars further, she could lose her job. This will have serious repercussions on her future and welfare of her family. As per Charter of Office of Human Rights and Responsibilities Act 2006 Victoria, a person waiting trial must not be automatically detained in custody, but his or her release may be subject to guarantee to appear for a trial at any or any of other stage of the judicial proceeding for execution of judgment. Moreover, under this charter, section 21, subsection 6, it clearly implies a presumption that a person should be released while waiting trial rather than detained. If there is a risk of non-appearance, then a bail condition should be used. It is understandable that the police do have two witnesses, but as per Evidence Act 2008, subsection 8 goes on to provide that Evidence Act 2008 does not affect the operation of the provision of any other act. Therefore, provision of the Bail Act will presumably continue to apply. Your Honor, under the Bail Act 1977, Section 5 AAA subsection 4, following conduct conditions can be imposed by this court, like report to the nominated police station, recite at particular address, curfew at nominating times, no specific person's contact, and Miss Morris is agreed to obey all these conditions. Moreover, her friendship with her old childhood friends is considered by the police as a threat, but Miss Morris doesn't have any contact with them, and it's all that they were her childhood friends, but they are not in contact anymore. Moreover, Miss Morris is willing to surrender her passport and also decided that she will not consume alcohol until the proceeding of this matter is over and abide by all appropriate conditions which the court wants to apply. She will abide all her conditions, and one more thing, under the Bail Act subsection 93, she had money for the surety and offers to put surety bond as well. At the last, I want to refer Victorian Supreme Court case Gravy versus Department of Public Prosecutor 2008, where the appellant was in the showcase situation and the court granting bail gave significant weightage to the possibility that the appellant may serve more time on remand than he would under any sentence finally imposed. So, presenting all the facts and arguments, I rest my case and request Honorable Judge to grant bail in the light of the above mentioned facts to my client. Thank you.